Welcome to Uncommon Knowledge. I'm Peter Robinson. Be sure to join us, by the way, on Facebook at facebook.com/UNC Knowledge. Facebook.com/UNC Knowledge. Today on Uncommon Knowledge, two of the nation's leading constitutional scholars on contemporary constitutional issues and on the Supreme Court that will decide them. Richard Epstein is a professor of law at the NYU Law School, a senior fellow at the Hoover Institution, and a senior lecturer at the University of Chicago Law School. Richard's latest book is The Case Against the Employee Free Choice Act. John Yoo is a professor at the University of California, one affiliation, University of California at Berkeley Law School. His most recent book is Crisis and Command, The History of Executive Power from George Washington to George W. Bush. Richard and John, thank you for joining us. As we tape this program, the new session of the House of Representatives is being opened by a reading on the floor of the House of the Constitution of the United States. Would you join Rush Limbaugh in calling this an exorcism?
I think it's a symbolic gesture, but unfortunately I want to make sure I know who's reading it before I decide whether it's a good or bad idea.
Richard, suspicious. Segment 1, Virginia versus Sebelius. On December 13th, U.S. District Judge Henry Hudson ruled that a central component of Obamacare is unconstitutional. Judge Hudson's decision. The law's requirement that Americans carry insurance or pay a penalty, quote, exceeds the constitutional boundaries of congressional power. The unchecked expansion of congressional power to the limits suggested by the individual mandate would invite unbridled exercise of federal police powers. Close quote. John Yoo, that is obviously over the top, right?
No, actually, I think this is right in keeping with where the Supreme Court's Commerce Clause jurisprudence has been going for the last 15, 20 years. The court has never faced a law like this where Congress said, you passive American citizens sitting on the couch, not doing anything, we are going to command you to go buy a product, go into the marketplace and buy something. In the past, the government's been upheld in the court when someone enters the marketplace, they want to buy something, they want to sell something, then the government can regulate you. But the court has never upheld a law before where the government pushed someone into the marketplace unwillingly and said, you must buy insurance or you must do that. That is someplace where the Supreme Court's cases have never gone before.
By long tradition, I think, I put this to you as a question, the government of the United States compels action only when it drafts people to serve in the armed forces and only when it tells you you must serve on a jury. Isn't that right?
That's basically right. Yes.
And those are under different powers of the government that don't involve interstate commerce, that involve the regulation of the economy. Those are very unique, discrete powers.
Or the operation of the public system.
White House Press Secretary, within minutes of this decision coming down, Robert Gibbs said the administration was confident higher courts would overrule Judge Hudson, finding all of Obamacare unconstitutional. Richard?
I think it's actually going to be a horse race under these circumstances. The great advantage that this particular theory has is that you knock out this portion of Obamacare.
The theory being what John just stated.
Right. You knock out this portion of Obamacare, but you don't have to take head-on Social Security, Medicare, or any of the other social welfare programs. If you had a broader theory of constitutional challenge, then in effect the entire system of public health and support would disappear and nobody would tolerate it. If, in fact, the only thing you're going to do is to stop something from going into effect as opposed to undoing things that are already in effect, and you can draw a clear line around it, then, in effect, the unpopularity of the system means that there's going to be relatively little political blowback. And even though this theory has all sorts of internal difficulties with it, like all other theories of constitutional interpretation, it may well be that it will come down to Justice Kennedy, and it could easily go to the way 5-4. So I think, in effect, it's a horse race.
So, political blowback. What you're saying is part of it's a cunning constitutional theory for largely political reasons.
No.
It constructs an argument that judges can stand, that they can swallow. Is that right?
I wouldn't put it that way. I think what Richard's saying is that some people think justices are very moved by what they read in the newspapers and opinion polls. Justice O'Connor was the person most criticized for this, trying to steer the court in a moderate way where they're sitting right in the middle of American politics. So actually all the political resistance and criticism, the high negative ratings of the polls, give give me if I'm wrong, correct me if I'm wrong, give the justices a comfort level to do what they should do anyway. They should do what's right. We want to make it easy. You know, all the Tea Partiers, all that are making it easy for the justices to do what's right.
I know the two of you, and I know your constitutional views. But what you have to do is, it seems, I'm giving this to you, and you're saying, well, of course Judge Hudson was correct. That seems to be almost your reaction.
No, I didn't say that.
But you've got an administration, a Justice Department. This law was drafted very carefully by who knows how many lawyers were involved. Nancy Pelosi, when questioned at one point as Speaker, 18 months or so ago, somebody said, are there constitutional problems? And she said, clearly startled by the question that had even been raised, said, are you kidding? She thought the questioner was kidding. How could it have gotten this far when there's an obvious and serious constitutional challenge?
This is the answer to that question is, if you tried to fire a bunch of buckshot and take down the entire congressional book of statutes, you're going to find that Pelosi's record will work. But the genius of this particular theory is that it gives you a hard line and a limited scope, and the only thing that turns out to be under that rifle at this particular point is the individual mandate under Obamacare. So you don't have the question of trying to sink an established set of public institutions. Is the argument right? Well, there's a fantasy land here. All of the arguments that Ms. Pelosi believes in rest on the decisions of 1937 and 1942, which are themselves outlandish misconstructions of the Commerce Clause. And this is kind of Randy Barnett's revenge.
Randy Barnett is?
He is the professor of law at Georgetown University who more than anybody else has proselytized on behalf of this theory.
All right. So, John, how does this make its way from Judge Hudson, district court judge in Virginia, to the United States Supreme Court, and how long will it take?
So it's in the Court of Appeals for the Fourth Circuit, which is the appeals court that sits over Virginia, Maryland, and so on. That'll probably take about 6 months to a year. Then it'll go to the Supreme Court. I could see it getting to the Supreme Court for a request for review. No matter what happens, it'll go to the Supreme Court, maybe by the end of 2011, by the end of this year.
In time for the presidential campaign.
Oh,
yeah.
yes.
Oh, yeah.
This will be pending before the Supreme Court of the United States in time for the presidential campaign.
Either that or the Florida lawsuit, which is on broader grounds.
Which is our next segment.
But they'll hit, and they'll become very much parts of the presidential campaign.